mentor. I'm a businesswoman and I'm into landscaping. I help using nature to heal ourselves. So you're most welcome. Today we are looking at inheritance, we are looking at making a will, and reason being, many families are in turmoil. We never know when we depart from this world. And we don't want to continue living this world with the family members disunited because of simple material things. So our learned friends today will take us through a session on how we can prepare ourselves, on how we can hand over whatever little we have acquired. Even if it is a dress, I think we should not leave people fighting for that dress. They need to know how to use that dress appropriately. So welcome, and I'm sure by end of the session will be better. And council, expect me next week in your office. I want to make a will. I've been talking about making a will, but I've realized it's really time for me to make it. Sorry? Thank you so much. Welcome. You know how you are going to conduct the sessions. You can guide us on how and when we can ask questions or clarifications, whatever is convenient for you. Thank you.
With permission from my senior, in our profession we have this we have a lot of bureaucracies. So usually the seniors are the ones that speak first, then us the juniors speak later. But here, my role is going to be very simple. We are here to talk about succession law, basically. And what does this succession law entail? It deals with management of estates, of properties. And this is because, like it or not, yeah, like Momo said, there are always those things that you have, you want to leave them to your children, even when you've organized yourself with your children, but without anything written, anything formal, you find your relatives coming in to now disorganize what is already a little bit organized, and that causes a lot of confusion. And then during this discussion, we hope to also guide you through what amounts to that valid document that we all know as a will. Because there are some people who will say when they feel like they are leaving this world, they call someone, they're like, hey, please record me here. This is what I want to do. I'm leaving this to Momo, I'm leaving this to Winfred. Is that a valid will? And then we look at things like if I have a company, if I'm a shareholder in a company, what happens? I don't have any of my children in this company, what happens? What happens to those shares? And then it also goes beyond, it goes to you're a money lender, for example, used to deal in finance a lot. So all those people who owed you money, what happens, things like that. And yeah, pretty much everything that you own, it can be a physical asset, it can be something that is not physical, but yeah, can be tangible, all that. We hope to be able to address that. And of course, the biggest, yeah, we called it an elephant, is always, I have my land somewhere, it is probably not known to the rest of the family, how do I deal with such situations? So we hope that in our discussion we'll be able to address some of those key aspects. And it's a learning session. We are always learning, so whenever you feel like you want to chip in, yeah, feel free to chip in and ask where you need some clarity. Yeah, I think that is pretty much it. We are going to be talking about things like Succession Amendment Act number this. Do not worry. We talk about like yeah, the Constitution 1995. Don't worry about those things. They're common. They're just English words and figures. So yeah, that's pretty much it. We hope you enjoy the session, and yeah, we hope to learn from you as well, and to get money for drafting the rules.
Yeah. As earlier on, I told them all the Swagger Matia. Most of the time I do lecturing at Swagger University. So most of the times I prefer to have a session so interactive, not a one-man's business. So I call upon all the people who are here to be free, because what we intend to talk about is in a day-to-day life. Succession law, as my colleague has said about it, it emanated a long way from 1900, actually before 1900, because our parents, our grandparents used to do these things. But the challenge that used to happen was that they were informal. And always informal things are easily disputed. What they used to say, Fred, you're my friend. In case God summons me, Kathy will step into my shoes long time ago. But due to the enactment or the evolution of law from 1900, the first law that partly dealt with what they call succession was the 1900 Land Agreement. I believe it sounds into your ears, where we had those white people coming into Africa. Because for them, they used to have it in their country, where they used to know the value of codifying a document or expressing their will so that they can keep their legacy on. But due to the laws that were brought by them from 1900, 1902, 1915, up to 1995, it still stood the test. And here today, with a new generation that will comply with such. So you shouldn't be worried about succession because it's a long-term thing. Today, we need to start from 1995, where our most supreme law is recognized. That's the Constitution. As my colleague said, that we're going to hear words like Constitution, Succession Amendment, the Succession Act, but that's immaterial, because as people, we have to first know the things in our own way of understanding. What succession is, what entails into succession, what a will is, who can make a will, what's the procedure of making a will, then how can I challenge a will, how does a valid will look like, what are letters of administration, grant of probates, what's the difference between letters of administration and grant of probates, how are they applicable, and then my colleague talked about the elephant itself, because we always make wills depending on the asset that we have. Because if you're having here a piece of land, then you're having 5 children who are out of the country, you have your sisters or brothers. In case God summons you, your children may not even benefit from the land that you acquired for their benefit. The uncles, the aunties always chip in, take control, and end up depriving your children the benefits that they're entitled to. So we're stemming from what a will is. In Uganda it's called ekiraamo. So what a will is, or how many types of wills do we have, ebika bya wills betulina, and then how can I make a will, who can make a will, who can witness on my will, how can it be witnessed, so what can I give using a will, what shouldn't I give. You know, we always call it bequeathing. What can I bequeath? That's mean what can I give, and what shouldn't I bequeath. But I would prefer to use the common English for the benefit of the community. So when I talk about a will, most of the people think that a will has to be written. But the general rule is you can put it into writing. However, there are those ones which are being left oral. Recently we faced a challenge with one of the justices of Supreme Court who passed on when she told the relatives that I should be buried this side. The husband was saying, ambassador was saying we have to bury her this side. So all those contradictions, but I mean is that how best can we fight all those challenges? Because once you pass on, you cannot say, you have no say. People will think for you, reason for you, and decide for you. So what's a will? A will in a I wouldn't want to use this word in a layman's understanding, but in ordinary understanding, it's an expression of your wish, how you want your estate to be administered and who is going to administer it, and even showing what you have as an individual, what you acquired when you're still praising God So a will is basically made by a person who is above 18 years of age, who is of a sound mind, that means mentally okay. But however, those ones who are not mentally okay, they can also make their wills, provided that at times they're mentally okay, at times they're not mentally okay. So in the state where they're okay, they can make that will. When they're not okay, that will not stand the test of being considered to be a valid will. So when you express your wish of how your estate, how you want your estate to be administered, what are some of the aspects that you have to look at when it comes to your will? Or what do you put embodied in your will, or what do you insert in your will? One of the most challenging things when it comes to a will is that the testator, that's the person making a will, makes a will and then he signs in the absence of the witnesses. That means that will is invalid, because when an testator makes a will, or the will maker, he has to sign in the presence of the witnesses, and those two parties must sign in the presence of a person making a will or a testator. So if you make a will, then you sign, then you tell Uyinza George, kindly take this will to Madame Momo for signing. And Uyinza takes the will to Madame Momo for signing. And then when there are some disputes and such things come up, it will be so easy to invalidate your will. Yet it was your wish that Mr. X should be my executor, but given the fact that you've not followed what is required, it has to be on the table signed. When Mr. Windsor is seeing, he signs. When Mrs. Momo is seeing, he signs. And then when you make a will, it's always advisable, and actually it's by law, that on every page you have to put your initials, and you have to sign on every page. And at times the person witnessing, they should also initials on each page, signed on each page. The reason as to why they always call in for that, there used to be forgery, whereby you sign on the last page, so they come and get out the relevant page, and then they use the same font, the same typographical means, then it looks to be the same, yet it is not the wish of the testator. So we always, in the will, we have to state how many children do you have, from which wife, from which woman or wife. I basically always prefer wives. Then from if I have an example, if I have 5 children from Kathy, I have to state that Mr. Gaswaga, Mr. Matia, those are children of Kathy. If I have children from now Namudu, I have to say that these are my children from Namudu in a will for better specification. And you should always state the property that you're having. I have a property at Nadia block this, measuring this, with a title. You always list them in the will for proper identification. Because remember, after stating the number of the children you're having, you're going to state the assets you're having, the movable and the immovable, because you're going to bequeath or you're going to give them out. So after identifying who the children are, the properties that you're having, then you will now come to the subject. I bequeath my property at Nadia 47 to George Uyinza. I give this lorry to Kate in a will, because they have to be indicated. When they're reading your will, it has to be indicated. Now, if you're having a child that you do not intend to give any asset, given that you had some challenges, for avoidance of your will being disqualified or being invalidated, you have to set the reason as to why you're not giving that child the property. If you don't set the reason as to why you're not giving out the property to that child, the will is going to be challenged, because as I talk, we have an estate which is worth 77 billion. We are at Family Division High Court fighting because the father didn't set the reason as to why he didn't give one of the child the property, and that child is our client. So one, we already invalidated the will. The father wished how his estate would be given out, but because of those errors that are not known to the ordinary person, leads the will to be invalidated. And as you prepare your will, some of us, given the fact that we have our status, we prefer a particular way of being buried, how funeral rites have to be exercised. At times we say that I will be buried in Kanungu. But in Kanungu, I want to be buried in the house. But on this expense. So if you want to be buried in a particular way, you have to set in the will. If you want to be buried in an electronic way, whereby your body can easily be visible by whoever wants to come and see, you have to set in the will. But however, you have to put where those expenses are going to come from. If you intend to sell an asset to cater for your burial, for that particular service, you have to state that the money that are going to be used when burying me must come from a particular apartment. Then you state. So when you appoint an executor, the executor always, now these are two different things. There's what they call an executor, or letters of probate, and letters of administration. You always hear those words. Letters of administration and letters of probate. Where a person dies leaving a will behind, or where the person applying is a widow or a spouse, whichever case, he will not apply for letters of administration. He will apply for letters of probate. And there he will not go to the Administrator General. You just go straight to court.
Some clarification.
No, that's what always distinguishes between letters of administration and letters of probate. Now, the difference between the two is that letters of probate, or grant, we call them grant of probate, comes in a way that somebody has passed on when he has already left the will. That's one. Two, if I leave my spouse legally married, because there's what we call wives and a woman friend. No more can say. Yeah, these things happen. Yeah, the things happen. They happen a lot. You leave a wife because you've been in Kampala with a woman friend. Now the woman friend wants to come and take over. A woman friend is a person who is not legally married to you. So you call them in a polite way, not the other way. On the street calls. Even concubine is polite, but there's how women, when they are pissed off to one another, when they're exchanging. So, a woman friend will not chip in.
Can't it be the other way around? The woman has many men friends than the husband.
Actually, it happens. Things have changed. And actually, I'm going to talk about it as well. So, when you pass on and you're having your spouse or wife legally married, that person will not go to the Administrator General. You will go to court to apply for grant of probate.
Now, question. So the only reason people would go to the Administrator General, even if you're married, is because there was no will.
No, if you're married and there is a will,
and there's no will.
There's no will. That's when you address yourself to the Administrator General. Oh, you a woman friend, but the children decides to say that we can confront the woman friend to our father, and the resolution is passed in the meeting. So you have to pass through the Administrator General. That's why you hear people advising, my daughter, to avoid such things. The 4 years can avoid such things. Oh, if you're having a person, bring that person so that you can get know the person. So now when it comes to letters of administration, a person has passed on, there is no will, there is no legal spouse. Now the children are fighting. They always pass through the Administrator General, who always refers them back to Assistant Cow or the L3 parish at the parish level to iron out the family differences, so that you can appoint one person to be your administrator. So that's the distinction between letters of administration and grant of probate. Now, there are instances whereby you appointed an executor. Madam Momo is going to be my executor when God calls me. Now, Madam Momo is not interested or is much more reluctant to go and apply for grant of probate. What happens in such situation? what happens in such situation is that a child may pick that will and go to court and tells that our parents or my mom or my dad picked Momo to be an executor, but this is 1.5 years. 1.5 years, Mom has not taken any step, given the fact that there are several reminders for her to execute her obligation. So now that child is going to be given what they call a grant of probate annexed with a will. There is called annexed with will, that they give you this grant of probate with a will attached that, however, we're giving you this, but there's a person who was appointed to be an executor. But given the fact that he or she has not complied or has not engaged into performance of his obligation or duties, now you can stand in for that person. Because at times we appoint friends, but when it comes to you don't want to take on. In that very will, when it comes to witnessing, you've made your will, how your things want to be administered. Some of us pass, some of the individuals pass on when they have money in banks, NSSF. Because I believe now, when I look around, except for a few, most of us are fit for, except even me talking, most of the people around here are fit for NSSF, what. So, in such a situation, when you get your letters of, when you're making your will, you have to state that I have 200 million, bank account number this, in this particular bank, this particular branch. In that, when a person appointed as an executor, now I'm talking about the will whereby you've left the will, a person appointed as an executor will easily fall up with a bank using letters of administration, grant of probate, certified, because they don't easily give that money when they're using the original. Either if they may ask you that original, they write to court to verify whether it's genuine. That is intended to avoid fraud. So they write back to court to verify whether these letters or grant of probate that are presented before them are genuine. That system is a practical measure within the parastatal bodies to combat fraud, mishandling of the estate of the deceased in such aspect. Now let me rewind back the will. We're at a situation whereby you're giving a property to annex your daughter, and leaving Matia, you don't want to give him. And we say that if you don't want to give Matia any property, better state the reason as to why. Because we always see parents get disappointed with sons and daughters. Because in all situations, the daughter has not acted like the way the parent expected. So it turns out to be a disappointment. So when the parent gets so hungry, be like, sija kuwa property, gendo kole hiyo, this is mine. And never say the reason as to why you are not giving. And when you give that property, there are some properties which cannot be easily given out. An example would be, you're an administrator in somebody's estate. Being an administrator does not mean that you own or you're the beneficiary of that property. You're just a caretaker. You're a caretaker of somebody's estate. So you cannot get the property where you're administering and you add into the estate that is your property. It's not your property. It's just like trustees. You're trustee, but there are beneficiaries behind. So those properties cannot be bequeathed. Now, recently we had a development that came out from court whereby a husband married a wife, or a wife married a husband, when the wife has some of the properties that were acquired before marriage. And when it came to bequeathing, the husband wanted to give out that property in a will. In his will.
The woman had property before getting married.
A lady, let me use that.
Okay,
A lady
Mm.
or a girl or whatever, but not a wife, had a property. Then they engaged in a relationship with this gentleman. This gentleman, they legalized their marriage. When the lady had acquired the property before the legal marriage. So when it came to the time of making a will, the husband added the property that belonged to the wife, which were acquired before the legal marriage in a will. So the question that was brought before court as to whether the property acquired by the lady, by a woman, a lady, a wife before, is part of the estate. And you know it's not always good to deprive somebody's sweat. Luckily enough, the court was sober enough and said that property had been acquired prior to marriage. We start looking at the property that were acquired after marriage. Now, that situation, there's a situation that seems to be similar to that, where I've been within a relationship. You have a child, we fall together, you acquire property, and then we legalize our marriage. The most differentiating aspect is together and finding you when you have. Now, together you acquire the property, then you legalize the marriage. Because always, contribution, I know women like that word so much. I contributed this. I earned for you. I cooked for you. I used even to call you take care of kids as contribution. So something that has been, you've worked together, acquire it, even if you legalize the marriage, still means that
mutual benefit.
you have mutual benefit. Which is different from the first aspect. I find you with your property, walking on the streets, I bump into you, you have your own assets, then it comes to be that I want to consider it as part of the estate. Now, even on the same aspect, there's a varying aspect whereby your intention is, you're the owner of the property, to make that the property is part of our property. If you bring much more into that this property, though I acquired it before getting in touch with you, I want it to be our property. How the story is coming to be, to show that there is an intention for you to tell that this is our property. Where you're picking money from that property, you bring into a home, you buy things, you share, you pay fees for the kids, you even share with the husband. That means that your intention is to show that this is our, not mine.
It has become
ours. Because we're using it for livelihood. We are picking the money that's coming from the apartment, I bring at home, I buy whatever is at home, I give you, I pay fees for the kids. That means that your intention is to show that this is our property. So at times when court is interpreting, it doesn't look into one angle, but it looks at the circumstances surrounding what was your intention. That's why you always find that women, they always say, because the intention was to make it a home, a family, so it will form part of the estate. So we need always to be so cautious and so careful how we deal with our property, how we want our property to be considered.
But that means most people are confused. They don't know what they are.
That's why you see, they always say, Baroya Babi. They have interpreted the law in a different direction, but that's what always happens. Your intention is so key in such determinations. Because court will always, yes?
In Rwanda, when you are getting married officially, they ask you, you want to kuvanga or not kuvanga?
You want to mix.
You want to mix or you don't want to mix?
You want your property to
When you are coming together, before you officiate your marriage, they ask you, how do you want your properties? Do you want them mixed or you want to remain separate? And I think that has
Yeah,
has put into
Now,
safety cards
the advantage with Rwanda, the law applicable in Rwanda, it's not the same law.
as Uganda.
For them, they are more.
So here in Uganda, when you formalize a marriage, the properties become a mixture. Is
Now-
it automatic?
No, it's not automatic, but your intention.
How do you know my intention? If let's say that this is my property, as I'm still alive, and somehow I die, meaning that I don't want to share my property with you, it remains it's mine. So how do you handle that?
No, at times that's what I was telling. The intention. You know, intention is a broad word.
Must be revealed.
The,
How-
inte-
when
the,
someone
the,
has
court, the court
already
will
died?
fetch the intention. Because when it comes, you know, when you go to court,
You have died.
And,
Remember.
You have
Now-
died, and I'm not saying anything.
for you passed on, now there's what they call witnesses.
Yes.
Witnesses in cases are key.
You must make a will.
Once they ask you a question and you're not certain, and you start going left, right,
Then it is
that's the
validated.
advantage where a lawyer will come in and pinches you in a hard way. If they ask, now imagine your son is in court, they'll ask, that property used to be for your mother, is it true? You say, yes, it's true. What shows? The title is here, it is in her name. So basically, when your mother was still alive, which main activity was being used, or what was the purpose? I mean, like, what the money that used to come out of that property. Did you know how your mother used to use it? Yes, buying food at home, because dad was broke, paying fees, paying electricity. Now you're seeing the intention is coming. That property was used for survivorship at home.
So it has to continue. The
Now it has
survival.
Also, maybe on that as well, since most of us are Christians, there is something. I attended a convention and there was an interesting question of marriage. When you're making your vows for you who are married, you say, all I have,
I give
I
you.
give to you.
So you've already
Yes, so now there was that
surrendered.
question which we had, and it was a conference of advocates, and we were like, yeah, marriage. Marriage is-
They believe in the church vows, the court itself.
No, it was just something that we were looking at. But I could, and some of us were. The bit about the law is it can be argued both sides. So some of us were personally, I was on the side of I can rewrite the intention from
From the vows.
everything of mine I give to you.
You've already made the intention.
And we are one person.
Yeah, we are now we become
And there's
one.
even a record where you are saying, I give you.
But that is still so I'm not quoted. That was just something of it was just a discussion that came up.
A biblical.
And we're looking at it, we're like, but as Christians, before you get when you're getting married, you're like, everything of mine I give to you. But then now, when it comes to the estate, you're saying, this is mine, this is mine, this is yours, this is like that. So what happens is vows, but it's just a by the way.
So legally, those vows can be binding.
It has not been tested yet.
They haven't, there's no.
Because even if you go to these things and you get married, you are legally married.
Yeah, but it's just something to think about. Yeah, sorry for taking it.
No, we need to know. Someone can be comfortable and say, yeah, I made a vow.
These are
and then
mistakes
somebody
we are
said,
making.
Are we allowed to make our own votes?
yeah.
But as long as you're guided with a rightful person.
Yeah. It has not been tested, though, that principle yet. I hope to be able to test it in court one time. So, yeah.
But there's still some,
There is a whole
there's a whole,
There's a big challenge
there's
to
a
that
big
aspect.
challenge. I think you lawyers, what you need to do, save us this trouble. I think educate people as much as possible. And especially these young people who are getting into marriage, they need to know what they are getting into. I'm telling you.
My daughter gets this, my son gets this, my husband this, so it's up to me to decide. Can I leave out some people I don't want to?
This is what you are talking about.
But basically, I was going to talk about it, but since you've asked, let me just do it right away. The new succession, the Succession Amendment Act that came recently last year, it shows the percentages that a person is meant to take depending on the situation. But however, if in your will you say that I do give this property to Betty, hope there is no Betty, to Betty,
To Bruce.
okay, let me use myself. If you say I'm giving this property to Matthew, I'm giving, my estate is 100%. Now, Mattia is my executor. Over, only Omusika. Okay. Yes. Omusika, I'm giving 70% out of my estate to my heir. That means that the percentage you've given is far beyond than the law. Because once you are appointed as Omusika, expect 1%.
Yeah. Okay.
Expect 1%.
So Musika is entitled to only 1%.
One.
Then 99 is supposed to be distributed.
Now,
Why give
now this is where women are trying to get benefit. This law still came up and gave them some good percentage.
So what is the benefit?
That you're getting a percentage more than that. Yeah. The hair is entitled to 1. This one's entitled to 40, 20, 45.
The widow
The widow.
takes so
With a
much.
will or without a will?
Eh?
If I make
No,
my will.
if you make your will, that is okay. But when you're distributing your assets in the estate, you should be so careful.
You have to be guided by
you
those
can't
percentages.
give your hair more than others. You actually has to get less. Less. If he gets better than any other party, that will contradict with the law.
Suppose I leave it in a pool, say if they divide it.
the way they see it?
But that's why there is a confusion. Because people are now fighting. So you have to be specific on how they should do.
Now you have to be so specific.
Yeah, but
Because people
Now
are
we
clashing.
have what they call linear descendants. Then the dependent relatives. Because previously it used to be dependents. Those people that used to give financial assistance, save school fees, medical
So those
bills.
ones will come now.
Yeah, they're entitled to your estate.
Even when they are 45, they still
So, council, this is something we need to understand. Now I have offered to pay school fees for some people. I'm just doing it as charity, helping them out. Is there an entitlement that they should continue?
Now that's why they removed the other word, dependent. Then in this new succession amendment of 2022, they say dependent relatives.
How dependent?
So now they become relatives.
Yes.
No, but even when they are 50, they will still remain dependent relatives.
You see now, let me give you an example. If a gentleman is on the road and is paying fees for maybe a son or a daughter to his cousin, and then is being knocked on the road, even if the son does not sue, the other person that is paying for the fees will come and sue
That's a right.
for loss of dependence, because he has been depending on that person. Now, since you've caused his death, you've deprived him the dependence.
So
that he
your
has
lawyer
been.
should take over the...
So he will come and he has the right to take on an action, and he will show that, you know, I've been depending on Mr. X because he has been paying my fees, he has been paying me visits, he has been showing me love, those things. So
Without make your will.
another scenario is, let's assume that that will, because the person who signed was a wife.
And some other person.
Now they always presume that wives are influential when it comes to such things. So the mind of the person making a will, called the testator, is not at liberty to make a proper decision because the wife is so influential.
Okay, I mean that's the...
We always, me and my wife, I get money, my own money. I go buy the property. I say that, you know what, my wife come and sign, put their own name. And
As
that,
a witness.
no,
The owner.
as a co-owner.
So you are
Even if-
jointly owning
Even if I don't put the word co-ownership, the law will presume
that you are
we
owning.
are joint,
I'm so sorry.
we own that property jointly. Yet that's why you always hear people saying tewateekako ssente
Yeah.
na kuyamba okusainingako n'okuteekako ennyina tewateekako ki ssente. You always hear those things. Then out of that you may find that a wife will easily, because when a wife is on and then you want to get a loan and you've not satisfied her of how the loan is going to be utilized, she'll be like sigenda signing up.
Yeah.
So if the property is co-owned, that means that the survive, in case one passes on, the one who survives remains the owner of the property. That's why you find that parents, the father can buy a property and say, this is my son, Gaswaga Majest, and me, Gaswaga Matia. By Gaswaga Matia, you find another property, Gaswaga Matia, Gaswaga Shon. But in the event that I'm being called or summoned by God, my son will just get my death certificate, go to the land office, have my name be registered or cancelled, then the property goes
to him.
And that's how we find the
Without
parent.
any legal authorization, you can do it. It's legal.
Because he has died, so you
I'm already passed on. So the property has
He
been.
has an instrument allowing him to take possession.
As long as he
From
gets
the
the
title.
death certificate of me and goes to land office with a cover letter, we always call it a cover letter, asking the registrar to remove me, the deceased. The registrar will remove me who has passed on, and the property goes straight forward to my child. That's why you find that parents at times they do that to avoid. If they have many children and they see that these children, they may not be at par when I pass on, they start doing that. Get the parent's name plus the child on one title.
Oh, okay.
So that when you pass on, every child gets the share automatically. Right?
if I don't, it remains in my name alone, what happens?
If it remains in your name, now you're looking at a situation whereby you want your children to be in peace. Oh, if I have like two spouses, I know when I pass on, number one or number two, actually number two is always so powerful, we'll fight number one.
Yeah.
And
But
takes,
number one is the one who is legally married.
even if he's legally married, because at times number two connects with a family member. And for avoidance of the things of going to court, has in court for 4 years. As a prudent man, as a prudent parent, man or woman, it would be advisable that even if you don't make a will in respect of the property, have your name registered with your son or daughter. Get this, register this with your wife number one, register this with your wife number two. In case you go, the wife number one takes, number two takes his without fight.
How
Now,
about if you have other children?
now, if you have other children, you always cater for them. Wife number two, another property, I'm there with Gaswaga Majes.
Suppose you don't have all those properties.
If you don't have all those properties, now there's no essence. You will die, you will die, and there will be no fight because you have nothing to fight for.
But maybe you have like a home
A home, the law recognizes a home always
for everyone.
for everyone, but basically the spouse.
About if the spouse is not there and you are the only one.
Now the children comes in. You know, the law says that if the most preferred person to get the letters of administration is the spouse, followed by children, then lineal descendants. So if
Remember, in your descendants is anyone who has been.
dependent relatives and lineal descendants are different. If the dependent relative, if I get somebody, I start paying fees,
That is a
medication.
dependent.
That's everything.
That's a dependent. Now, linear descendant, I don't know how they call it in Nyankole, but in
Your
Uganda,
relatives.
from the
Okay,
grandfather,
grandfather,
daughter,
okay.
yes,
Even
those,
when my grandfather had 5 wives, that no, not my
But
grandma,
now there's
now
this
they
issue
can't
of
play.
dependence. I think we've been taking on people just for charity, and then they are becoming.
If they know you are low, of course they that's why
because I can give you a scenario. There used to be a gentleman in a district, a western region. I don't know whether it falls within the western region.
Properties, and I put there a caretaker, and I'm paying him monthly salary.
You have no kids.
Sorry. Now I have land like in the village. Eh? I'm not living there, but I need somebody to caretake that land. Now tomorrow I want to sell it. This person who has been caretaking, does he have a right on my property?
Yours.
Now that question is a question which does not fall within the ambit that we're discussing today. But nevertheless, we
now
shall
in
have.
the event I have even died.
Now you've brought it back. But those are two scenarios.
In the event
Now,
I have
in the
died.
event that you are alive,
You have died.
no, the Mr.
Okay, the event I'm alive.
The caretaker has no mandate to stop you from disposing of that property. Because just a caretaker.
It's just a caretaker.
Yes. Now, in the event that you die, there are two scenarios where you have children and where you don't have children. Or in the family, you're the last person. You ever seen those families? Because I've ever seen one where the gentleman had only 2 kids, but his kid produced anyone. So, if, let's say, you have children and you pass on, and then the caretaker will be recognized as a caretaker. Reason being, he's not depending on you. The word dependent means that you're depending on me, you're not giving me any service. But the caretaker is giving service.
And it's being paid.
And you're paying. Now the service also varies. Which kind of service is the caretaker offering? He's not extending to taking you to the hospital, looking for a doctor with you, come and make your day, talk with you, but basically looking at the animals, gardens. Those are scenarios that vary. If the caretaker crosses this part,
And becomes like family.
that you're vulnerable, no one is at home, his animal comes, closes, locks the door for you to sleep, opens the door for you to come out, make sure that you've eaten.
The children have to take care of.
Now all those scenarios totally
Yes.
different.
You abandon me, I abandon you.
Yes, they're actually different. Because actually, I think 2 days back, somebody was in court, and then the person that he met a gentleman in the hospital. This gentleman was well loaded here in Kampala. They say have some good structures in Kampala. He had four. I had two sons, then 3 daughters. All of them were well qualified. The one who had the minimum qualification had a master's. Minimum. They were all working in good entities. Some are out of the country, some are in. So the father fell sick and was working at Mulago Heart Institute. But neither the wife nor the children appeared. So this guy came as he came to take care of his mother. So he found this gentleman, old gentleman, here also suffering. So he started taking care of
both of
both.
them.
So the mother was discharged. And then he started coming back for this old man from the hospital. To pass by in the morning, he's a consultant. To pass by in the morning when he's going to work. And then bring lunch, or sends the wife to come. And they took good care of the gentleman. That gentleman was inserted, I think, a metal 4 times in the heart. So the 3rd time, he called that gentleman. They met up in one day there. He drove with the gentleman to his home. He has a fancy home. Of course, I had the opportunity of seeing the home. He told this gentleman, you know what? I have sons, I have daughters. Even he went online. He showed him that this is my daughter, these are my sons, but no one of them. When their mother fell sick, they all came back in the country to treat their mother. But me, when I fell sick, nobody came back. So I think this gentleman got pissed. He first sold the first asset. He carried that money. He took 50 million to one of the babies' homes in the country. He carried 100. He went to church, donated. He carried money. He went to where this king comes from, Rwenzururu, donated. He told us the gentleman to look for buyers for a second building in one area. He sold it, 500 million. he told that gentleman, you know what? I will not give you the property, because when I give you the property and they pass on,
They'll come for
it. But I'm selling that property. Sell it. When you get the buyer, come and sign. Okay, he signed. They gave the gentleman the money. He gave 300 million. That gentleman, I don't want to see where you're sleeping. Go buy a house. I want to see a house with a big compound. The gentleman went, bought, invited the old man. The old man
to see the house. He
became so happy. So they gave a room to that the old gentleman
To
in the
live
house
there.
to stay. So he would feel so comfortable. Here, you know, at a particular age,
You want company.
you want company. They are kids, and you know when you grow up, you also start falling into love with the kids. So this gentleman bought a house for himself.
And it is documented. It is his
Documented. The old man is not affected anywhere.
money.
So the man sold most of the property like that, and then he left me with the amount. So when he was about to pass on, he sold the last property, and then he had a grandson from, I think it's a son to a sister, but he's mentally off, so he bought him a property. But given your status, be there, so he passed on. So during the burial, all these people came, the big people, fancy cars parked where,
They've come to claim.
good service providers around. So, in the will, he made a statement. My wife, my beloved wife, my sons and daughters, God has blessed you with what you wanted, you have achieved it. I've gone, I've not been in peace with you, you deserted me. But I hope you don't come with fancy life during my burial, because you will be embarrassed. And you know the person who was reading that, when you're reading a will, you read what's in it. You cannot spice it up. So now the children got offended.
Because of that statement.
That statement. So they thought, now they started following up this consultant gentleman, that it's you who sold the property.
Of course.
Did this and this and this. The gentleman was like, yeah, your father sold the property, and I was a witness. The lawyer was there, the chairperson was there. So the agreements are there. He sold the property. But imagine if he didn't sell and he just
Died.
transferred it to this gentleman, what would happen?
I know.
So he didn't
It's better, it's always good if you're sure that you've reached a particular age where you're not going to require a loan, going to the bank, do this and this and this. It's always good to have that property, to have co-ownership. Because one, you're cutting the expenses that your son or daughter is going to incur to pay the stamp duty to transfer that property. Because for it, you don't pay stamp duty.
If it is in my name,
If it is your name,
and I want to
and there is a co-owner, me and you on the title.
no, if you are not,
If you want to
you
bring
want
me,
now, you pay the tax.
that one you have to pay the tax. If you want to bring me on the title, you have to pay the
That's
tax.
not cheap.
But when I die as a father, my son will just get the death certificate, pay 15,000, go to land office, and have it into his name. So at times, the money we have is not the same money that our children are having. Related issues. Divorce is being determined by court. Giving out property is a personal wish. Giving out property is a personal wish. Now, here you're fulfilling your wishes. You have your property, you want to give your daughter and son by way of a will. First of all, make sure that your will meets the standards of what a valid will is, or what it has to be. 2, make sure that people or the persons that are helping you to witness are trustworthy. Because once you pass on, trust turns out to be untrust. The people that are witnessing on the will are the very people that may come around
And turn against.
and turn against.
Confuse things.
Confuse things.
But now how do you know this
Now,
person?
you see, these wills,
We have
these wills are not kept by every person once you make a will. There are people that want to keep wills. We have lawyers,
You sell people's property.
we have lawyers, we have the chief registrar, high court, and then the religious leaders, the reverends, the fathers. So you have to be having 3 people. That I have a will as your lawyer, the church elder or the church leader has a will,
They keep on changing.
and then the chief registrar has a will. The reason why they always say that will must be given to 3 people. In case this will is manipulated, even the
Those
bank,
people will come
if the will is manipulated, then those other 2 wills will not be manipulated. That's why those people give at least 3, even know that you've passed on. And even your lawyer will get to know after, hey, boss in Bundi, you food there. But the church is a must. But you could just to give the last. Yes. So when you're making your will and it meets the standard and it's in good custody, now you can bequeath your property as you do wish. At times you look at your children and you assess. We always know to assess our children and say, God is a competent child. This one I'm worried. You be like, this one, if I give, this one, if I give, maybe he can take care because he knows how to manage things. So you can easily see. But that's because your intention is to give each and every one equal according to your wish. So, in our fulfilling your desires, and at times you see an example. If I may use this property may be worth like maybe 100 million and above. What is the revenue that my son or daughter has to pay to remove this property into my name? Now, another thing is, I'm leaving a will, but this will is going to be controlled by an executor who may mismanage the assets. I'm going to leave Mr. X as my executor, or I'm going to leave Benson, my first son, as the executor. But this first son, he will give the property to the girls.
I think to me,
It's called legacy in the succession legacy. I'm going to give you 2 scenarios. One, if I have children, I give out, if I have 5 children, I give out the property to those children. I make a will when I'm still alive. But before I die, now the person that I gave a property dies before me in the will. And that person who has passed on that had given a property has a child, a grandchild.
So the grandchild
So,
automatically.
that property will vest into the child. Now, if I died giving a property to my son, and that son of mine has a woman friend, not a wife, a woman friend who is not legally married,
She does not qualify.
the woman friend does not qualify to take property.
if he has a child,
If as a child, the child will take the property, not the woman friend.
Suppose he has no child,
But-
the daughter
But if there is no child, and I'm legally married to her, that's my son is legally married to her, the property will go into
Goes
the
to the
wife.
woman.
But suppose they don't have children.
Still the woman is.
No, the woman.
The woman qualifies.
they depend on
If the woman is not,
Married.
if the woman is a woman friend, if the woman is a woman friend, and then this son that had given the property passes on, and then I die, that property will come back into my estate, and it will be disputed according
According. But now supposing
you die. the people who are living decides for you.
And that is why we want to understand, so that tomorrow when you have died,
When you are alive, you make a will.
I will retire alive.
Now you see, when it's a home and you die, always the living home. But there's what we call residential holdings.
Yes.
Okay, let's listen to this one.
Now, residential holdings, these are basically homes like parents used to be with their children.
That is a family home.
The family home. Or let me call it a matrimonial home. And that residential holding has some burial grounds like you stated.
Yes.
The law prohibits, and they always say that the surviving spouse remains in the residential holdings.
Now that's
Now the scenario is Tali wo mama ne tata wo na ba akola.
But I put it in my will that this house should not be sold. They honored it.
You can put it into the will that this house is not to be sold and it's going to be used by all my children.
Yes, the children, grandchildren.
That is a good thing if you set in the will. That no, this is a home. I'm not going to sell. No one should sell, but whoever wants to be home will come back home.
Actually, just to supplement on that, the new act clearly says that the testator, the one who is making the will, shall not distribute in a will the principal residential holding and other residential holdings. I hope I'm not getting it.
Okay, now, this is a principal residential.
What he's trying to say is saying that if I'm making a will, Serena to give out the home.
Now, like here, this is our official residence. Now, if in the will, I'm not going to distribute it.
No, you cannot.
So what will happen?
You can leave it another.
No, you can.
But there, will start fighting for it.
You can clearly state that this property of mine, for example, Momo's home, is going to probably belong to my children, but the same should never be sold.
But now we are looking at the going concern. In the event, they can no longer manage or they are no longer able to sustain themselves, and they want to sell and get a living. What will happen?
So also the new law states, even when you look at the format, it provides for a residential home. You can, if you're a spouse, you can live with your husband until his death, or children until probably their death or something. It gives you a provision.
Bruce, listen, what I'm saying.
Or Commonwealth countries, whereby if Uganda is part of the Commonwealth country, that means that the law of Uganda applies to them. So they will look at the most place where you've been domiciling mostly. Where have you been staying most of your time? And where would you wish to be buried? Uganda, Canada. So your will determine.
What about the distribution of your property? Let's
Now,
say you have some in one Commonwealth country.
Yes, basically you can easily put in your will that you list the properties in Uganda, you list the properties in Canada. So you say, now in Canada I have 5 houses, in Uganda I have 5 houses. I give this property, one house in Uganda, one for my daughter, and that very daughter I give her a property in Canada.
But my question is, I can just have one will, well, whichever country I choose to
Yes, you
grow
can,
up
as long as it falls within
And it's
Commonwealth.
applicable to all the countries.
If it is not, now you have to comply with the laws of that country.
So that means if you have property in the Commonwealth country and the other is not, so you have to have 2 wills.
2 wills. One to apply based on the laws of that country, another one. Yes. So I want to talk about, we talked about
Before you
ownership,
go,
whereby you have into percentages. We can come, all of us here, then buy a property which is 100 million, saying that Momo has 10%, Matia has 5%. So what happens when you pass on? That percentage is being transmitted to your administrator.
the administrator is the one who will receive the 10%.
For your estate. Now, the administrator is under obligation to distribute the 10 to the beneficiaries. Now, they will be guided by the Succession Act. who is meant to take 1, who is meant to take 24, who is meant to take 75.
Wow.
Then, in a situation of joint tenancy,
In a situation of joint tenants, that me and my land colleague here own a property jointly without percentages, and I die, my children will not come claiming from him. He takes the property.
What?
there are two. There is joint tenancy and then there is tenancy in common.
Now let me make it clear, because it's a constant I've seen all around. It's a constant.
So they don't have any share on
Joint
on
tenancy.
If it is joint tenancy.
There are two things. There is joint tenancy and tenancy in common. Now, let me start with tenancy in common. Me, my land colleague, and George, we come up together, we buy a property, we say, Mr. Ambrose, you have 10%, I have 10%, George has
and it's documented.
80%. In the process of transferring, we're going to indicate on our transfer the percentages that you owe me. So it will go onto the title. In case, God forbid, I pass on, my son will come and say,
And claim the 10%.
give me the share for my father. And when he gets that share, he will have to distribute it to the other beneficiaries in a period of 2 years and file an inventory. Now, joint tenants, if we own the property, me and my land colleague and George, I pass on, the property will vest into the remaining. If my colleague passes on, George will take the property.
And if it
Now, if
also
all
goes,
of you die,
If all of us die, it is so hard in that situation. All of us die. But if it happens that now all of us are dead, now it will come into back to the children.
Goes to the estate.
Goes to the estate.
respective estates.
Of the last
In the
owner.
in the
of
event
the
last person who died.
in the event of simultaneous
three
death
of you.
of joint tenants, the land is taken over by the respective estates.
Estates.
if you die same time.
At
Yes.
50%.
An example, in the same car, we died.
Okay, now in the
So now
event you
our
are the only one
administrators-
who was the last to
Until now, as
have-
the remember when if we are two and I
they've
pass
gone
on,
out, they
I
are
am
no longer
out.
out.
Everything
Okay.
has been vested
Okay,
back
the
in.
other person.
So in case he passes on as well, his estate
Okay.
takes over.
So
But
now
now-
the
now-
last person who dies,
then
the
you mean
estate
after
goes to
that
the
means
surviving.
It is like
the
this.
only
The surviving
surviving.
tenant, the surviving tenant is
The one who
the one who takes over.
Oh,
That is for a joint. That's for joint tenants.
Joint
And that is why you
tenants.
see most. Also, I think while we're still there, property that is owned under joint tenancy is not included in our will.
Hey.
For those
Because
specific
it's-
reasons.
yeah, yeah.
Yes. If I own it with you and I pass on, it automatically
Good.
goes to you.
So
about
people
the share
need-
I have put in
And-
So people need to be educated
children
when
are
they are buying things, how they want it
That's
to be
true.
done.
That is it.
That is
Joint
what
tenancy.
That's why
Yes.
people are really fighting because they
Yes.
just
But
seem
you have
to
your
be
people, I
there.
have my people.
Yes.
Yes.
I pass on.
As if you have some. Don't worry. We can easily iron it out when you are
Yeah, so for joint tenants, there are two tenancies that we're doing.
Tenants in common.
Tenants in common
And joint.
and joint. For our understanding, tenants in common, you put it in percentages. And so that one will automatically go to your estate.
Yeah.
But where it is,
Joint.
where on the title it is Bruce and Winfred
Yes.
as joint tenants, and Bruce passes on, it automatically goes to Winfred. No one from my
Let me
side
ask,
is going to come and say,
Now, like
I
you have a
something.
land title,
Lately, young girls, young girls
that is being unfair.
get married to
Rich
or
old
That-
man.
that
be
law
in
is
a relationship
fair.
with an
God
old
has
man
put in money.
who are
So you are
having
taking
property,
everything and if you
and
die,
then
you
they
go to
convince them, they tell them that, you know
Yes,
what,
the surviving
better
tenants.
for you to put in, you know, my name on the title. And you know, a person of like 20, 26 can easily convince a man of 60.
60.
And the man will do
That's
that
surviving.
in the name
On
of
your
love.
own
In
way.
the name of love,
When the man passes on,
That's why people are getting problems. They don't understand that.
And you find
There's a lot.
most couples actually these days, I see them rushing. Hey, me and my husband want to be what? Joint tenants. And just them have understood it. They're like, yeah. But the beauty about that though is, if okay, it becomes a bit difficult where it is the man who has died and it goes to the wife, and now everything, of course, is now going to move to the wife's
Right.
estate.
And also men can benefit.
Yeah.
If I have a woman who has money, but it puts me there, she passes on.
Yeah,
You get
it's
Both
everything.
wives. And then you get another wife and the other children.
Life has to continue.
That's why Council
Yeah,
said,
no.
said the other time, that
It's about basically our children in respect of such. You see, parents, you may be worried, you may be like, I'm 8, I have a child who is, I have a child of 7 years, I have a baby of 2 years, I'm worried about the people, the people's concern.
Come on, Sinamno.
You know, when you steal a minor or an infant, at times you don't understand what. And at times women tend to protect their property much more, because the children are ever on the mother's side than the father's side. You may find that you may wish to have a property in the names of your child who is still living, and then you always register that property into the child's name. But once you register that property into the child's name, as a woman, there are some things that you have to put into consideration. Make sure that that child is so close to you than the father. I'm not teaching this to discriminate, but for the purpose of protecting. Because at times men, if I'm broke, I can say, let me sell, I'll get money and buy. But a woman is so hard to sell that property, and this otherwise. So when you put that property in the child's name, who's still a man, make sure it's so close, you're doing at least 50% of what's meant to be done as a parent. Because if you want to have that property removed from the names of the child, you're going to apply for the guardianship order. So the guardianship order, they look at some of the things, whether they've been relevant into the life of this child or not. So if you've been relevant into the life of this child, by evidence, not oral submissions, by evidence, I pay fees, I pay medical bills, I'm doing this and this, the court will grant you the guardianship order. And that's why you see that at times, if a woman is worried about a man, and there's a likelihood of divorce, suspicion of divorce, that he puts her property into the names of the child, then keeps the child so close. Because when the child is before, as a date of 18, a man cannot easily apply for custody order. They always give the mother, meaning that your property is
Still
safe. Because the child will listen to you, and the father was getting another wife, and you will be having the ground to hit, like they always, you may always beat us. Okay. So it will be so.
Yeah, Council.
But when you intend to hide, you should be knowing the consequences.
Those are some of the consequences of hiding.
And the consequences of marriage, legally, it has the benefits and the disadvantages.
Yeah.
So if you own the property and you marry, you cannot obtain money from the bank unless the spouse
but the property
Even if it is
they are
yours,
seeing
as long as
is
you
the
marry.
one of the marital home.
No.
Only marital.
Let me make this right. Publicly is not marital. But anything that is being used to derive income to sustain it.
You have to get a consent.
Yes. There are very many cases.
And that involves even the forest or the banana place you have in the village, where digging matoke from cassava, and that cassava is being used, you have to get a consent. Because anything that helps the family to sustain, it's not only the matrimonial.
Derive sustenance.
As long as there is income or support that's coming from that piece of land, it's considered to be part of the matrimonial house, and you need a consent. That's why you see that banks are facing challenges if they give a loan.
With some lady.
Because there is previously.
You would go to Kabaka, report to Kabaka, they get a book, a succession register, they write your name, a daughter to this has been given this part of land. They give you a succession certificate. Now, you look at the custom by then, how was it applicable? Were they in succession or it came after succession? Because recently the Attorney General came up and said, all land that falls or calls for succession certificate, that means that if your parent passed on like maybe in 1940, that means that your land falls within the succession register. So it has to be given by Kabaka, not court. Unless you think that what Kabaka has given is not real okay with you, then you can go to court. Actually, before reaching to court, Uganda had their own courts.
Yeah.
So you have to first go through those courts. And actually, High Court would be at the Supreme Court regarding such matter. So now, if you got your land from your father, basing on the custom, you first look, what does the custom say? Does when there's giving you land, inheriting from your parents, but when the land is for a particular clan,
You don't
just
sell it.
use, don't sell, use, give your sons, the sons give the grandsons.
If
So
it is
depends.
customary, that means it is for a particular
Now,
clan.
an example would be in Mugisu, their land is not custom. In Bunyankole, I'm not certain, but it's like when those days using the king of Bunyankole who's about to come back. So you see that how the system was centralized in Karamoja, whereby you could just graze land anyhow, graze communal land.
Communally owned.
So if they give you, that means that they are giving you to stay, not you to take. So it would be so difficult for a wife to come and start saying that
That is
because the property is a community,
almost communal.
communally
You
owned.
can use it there.
Now this is actually you are fighting with the Malawi. What is the land?
It was just passed last year by the parliament.
1%.
But you'll be angry. You give
But
1% and the other
No,
goes
that's
to
why
like
you see that
Yes,
if you
I
want
have
to
African
circumvent
orthodox.
all that, you can give
Fair
your
and
property
fair.
still alive.
Yeah.
You can do it.
You
Even when you're
can
still alive.
give your property when you're still alive. Because there are situations whereby you reach a level knowing that I will not survive. There are those situations.
I get
If
it.
you want to beat the law, do it when you're still alive. Transfer the
That
property.
is another way if you sell, you are the loser.
Maybe castle.
You can't sell. That means you will be.
How the law is coached in a situation that the following shall, the word shall is a must.
Mm.
The descendants, the lineal descendants, spouse, the heir, and then the dependent relative. So they are being given their percentage.
Council,
So
you are a lineal dependent.
the two positions.
You,
Yes. Once,
you benefit from two positions.
once you're being appointed,
As a head.
And here.
now there is say in the will there is an executor.
Mm.
In that will they say, George is my executor. Then Momo is my heir. So an executor and a heir, they are different from the will.
No, they are talking about a head.
Must you have a hair?
Yes.
Eh?
A hair is not a must, but
Okay.
it's a traditional
You
style.
can even put the hair with you.
It's a traditional style. Even the hair can be appointed when you're ready.
That's what they were pointing here.
So you can decide.
But for avoidance of all those lacunas that were created by the parliament, it would be advisable that let the property be distributed when you're still alive.
Yeah.
Because when you're still alive, even the children will not go into the trouble of eyeing one another. Yes. Tested and lying tested.
And they tested.
Tested means that you've left it. Tested.
There's no will.
Now, if you're an administrator, that means that the person you're administering the estate died without leaving a will.
Right.
If you're an executor, the person left a will.
Right.
And in that circumstance, a person who is called an executor will be given grant of probate. Now, where a person dies without a leave, without leaving the will, you will be given what they call letters of administration. Now, Momo, you have letters of administration.
Letters of administration.
Now you
You
want.
have misunderstood me.
I'm coming there. Now you want your sons.
The whole, the children.
Put down my will. I know most of you here. I know most of you here have
Yes.
some of them are special, some of them are usual. Endeavor to do research
Every 6 months.
after every 6 months. Then have those land titles calculated The reason for calling of such we have fraud that are manipulating people's signatures, especially if they know that maybe the husband passed on and the property is not yet transferred. They can easily manipulate the husband or the wife's signature and they transfer the property, and you just wake up tomorrow when they evict you. But if you put on the caveat, the added value caveat is so hard for the registrar to know the caveat without calling the person who caveated. They do it.
These days, you have to appear in person.
In person.
Let me give you an example.
If we
Told those registrars. That Nigeria told those registrars that if on a land, a particular piece of land, you create a second title on that land that is personal, you yourself, not as Minister of Lands, it is personal. If you withdraw the caveat without countersigning, now you're going to, in case that caveat has been removed illegally, you're going to be liable personally. Now there's no registrar who is willing to take on the personal blame. So you should endeavor to put those into consideration. To do caveat lapse, that means that there must be having a genuine reason. That the caveat has no basis. An example would be if I'm the registered owner and then I have a caveat. You cannot lapse the registered owner's caveat because it is my own property. But you as the owner, you don't lapse, you remove it. So if you're the owner of the property and you have the caveat, they will not lapse that.
Then you go in your person puts a caveat by court order, and then they, that case
Orders by caveat, in most of the times the order specifies the time. That caveat is going to be valid for a month.
So you can renew.
So when the month lapses, you can easily remove it because there is no basis. But you've hinted about the issue of caveat lapse. You know, when you lapse in caveat, they give you a notice, which notice has to be advertised or posted for those are 60 days. So if you're doing a checkup with your land in the period I've told you, it will be so easy to identify such. But if you sit back home with your title, it will be so hard to know. And you will find that the caveat has been withdrawn, the property has been transferred. That's why I'm encouraging your family to discuss a few things that we can share that you wouldn't share in the chambers, because when you come in chambers, it involves costs, consultation, but here, be freely, interact, then keep on sharing knowledge. You share what God gave you for others to benefit.
Thank you. Thank you. Thank you so much. Thank you.